What if I told you that the UK immigration system you've been carefully planning around has already changed and nobody sent you the memo? Right now, thousands of international workers across the United Kingdom are operating under outdated information, submitting documents that no longer meet legal requirements, and making life-changing financial decisions based on rules that either no longer exist or haven't even been confirmed yet. The stakes couldn't be higher. We're talking about your visa, your career, your family's future, and your path to settlement in the UK. And the window to get this right is closing fast. Stay with me because in the next few minutes, I'm going to give you the clearest, most structured breakdown of the UK immigration overhaul that you will find anywhere online right now. Welcome back to GoUKGo. If you're new here, this channel is your go-to source for no-nonsense, accurate, and genuinely useful immigration information. Today, we are tackling what is arguably the most important UK immigration topic of the decade. Between July 2025 and April 2026, the UK immigration system is undergoing the most significant transformation it has seen in years. And the single biggest problem right now isn't the changes themselves. It's the fact that confirmed changes, proposed changes, and future confirmed changes are all being reported and discussed together in a way that is genuinely confusing and frankly dangerous for the people whose lives depend on getting this right. So here's what I'm doing differently today. I'm giving you a clean, structured, zero speculation breakdown divided into three distinct categories: what is already law and in force right now, what is still being proposed and decided by the government, and what is confirmed for future dates but hasn't taken effect yet. This isn't opinion. This isn't guesswork. This is exactly what every international worker, care professional, student, and dual national in the UK needs to understand right now. Let's get into it. Let's start with the changes that are already confirmed, already implemented, and already affecting people as you watch this video. These are not consultations. These are not proposals sitting in a government inbox somewhere. These are active rules that you are legally required to be operating under if you hold any UK visa right now. The first confirmed change took effect on the 22nd of July 2025, and it hit two groups particularly hard. From that date, overseas recruitment for care workers and senior care workers was officially banned. If you're already living and working in the UK on a health and care worker visa that was granted before that date, you are protected and your status is not affected. However, brand new applications from overseas for those specific care roles are no longer being processed. The international recruitment route for care workers is closed. Full stop. On that same date, the 22nd of July 2025, jobs classified at RQF levels 3 to 5 were removed from the skilled worker visas list of eligible occupations. RQF stands for Regulated Qualifications Framework, and levels 3 to 5 cover what the government classifies as medium-skilled roles. Think certain warehouse supervisors, retail team leaders, hospitality managers, and similar positions. These jobs can no longer sponsor skilled worker visas. If you are currently working in one of these roles and your visa renewal is approaching, you need to check your specific occupation code against the updated eligible occupations list on the official government website without delay. The second confirmed change came into force on the 16th of December 2025, and while it may seem like an employer issue on the surface, it has very real consequences for workers. The immigration skills charge, which is the fee employers pay to the Home Office when they sponsor an international worker, increased by 32%. The rate climbed from $1,000 per year to $1,220 per year for most businesses. Charities and small employers pay a lower rate, but also experienced a proportional increase. Now, here's why this matters to you personally, even though you don't pay it directly. Employers factor this cost into every single hiring and renewal decision they make. Some employers who were comfortable sponsoring workers at the previous rate are now reconsidering. Others are narrowing their sponsorship to only their most critical, highest priority roles. And some are using this increased financial burden as a justification to offer lower salary packages in an attempt to offset the additional expense. You may not be writing the check, but you are absolutely feeling the impact. The third confirmed change is the one that created the most immediate panic when it landed, and it came into force on the 8th of January 2026. The English language requirement for skilled worker visas, scale-up visas, and high-potential individual visas was officially raised from CEFR level B1 to CEFR level B2. To put that in plain terms, B1 is intermediate English. B2 is upper intermediate, roughly equivalent to university entrance level. If you are applying for or renewing any of these visas and your English test certificate only demonstrates B1 proficiency, it will not be accepted. Not as a partial pass, not with a letter of explanation. It simply will not be accepted. You need to demonstrate B2 level across all 4 components: speaking, listening, reading, and writing. Not 3 out of 4. All 4 without exception, and your certificate must be from a currently approved test provider and must not have expired. Here is the specific danger that caught so many people completely off guard. If you sat your English test before the 8th of January 2026 expecting to use it for an upcoming visa application, and that test only demonstrates B1 level, you cannot use it regardless of when it was taken. You must retake the test at B2 level. If your certificate is from a provider that has since lost its approved status, you face the exact same problem. Go to the official government website right now, find the current approved provider list, and check your certificate against it. Do it today, not next week. The fourth and final confirmed change that is already in force is the Electronic Travel Authorization System, the ETA, becoming strictly enforced from the 25th of February 2026. This primarily affects visitors from visa-free countries who now need a pre-approved ETA before they can travel to the UK. But it also has a critically important and widely misunderstood impact on dual British nationals. If you hold both British citizenship and citizenship of another country, you can no longer travel to the UK using your non-British passport without either carrying your valid British passport alongside it or paying $580 for a certificate of entitlement. If your British passport has expired and you've been relying on your other passport for travel, this is urgent. Renew your British passport immediately. Those 4 changes are confirmed, in force, and affecting real people right now. If any of them apply to your situation and you have not yet acted on them, please stop watching after this video and deal with it. Now we move into the second category, and this is where clarity matters more than anywhere else. These are the proposed changes, the ones that are not yet confirmed, not yet law, and are still actively being decided by the government as of this video. I want to be absolutely clear. These changes came from a government consultation that closed on the 12th of February 2026. The government is currently reviewing everything submitted. A formal announcement is expected by the end of March or early April 2026. Until that announcement is made and published, these are proposals. They could be implemented exactly as written. They could be significantly modified in response to the consultation feedback. Or some of them could be scrapped entirely. Do not make major life decisions, financial commitments, or long-term plans based on these proposals as though they are already confirmed law, because they are not. The most significant and most contested of these proposals is the extension of the standard indefinite leave to remain qualifying period from 5 years to 10 years for most international workers. This single proposal has generated extraordinary political opposition. Over 237,000 people signed petitions against it. 35 Labour MPs wrote a formal letter specifically opposing its retrospective application to people already living in the UK. Immigration lawyers, economists from the London School of Economics, and migration experts from Oxford University all gave evidence to Parliament raising serious concerns about its impact and legality. The government is also proposing a 15-year settlement route specifically for health and social care workers, a group it classifies as lower skilled. These are people who came to the UK, in many cases specifically because of government recruitment campaigns, and who built their lives here expecting settlement after 5 years. They could potentially be looking at a 15-year wait instead. This proposal has drawn particular criticism given the ongoing staffing crisis in the care sector and the very real exploitation risks created by keeping vulnerable workers tied to a single employer for such an extended period. Related to these timeline changes is a proposed mandatory work requirement for dependents, meaning that not just the main visa holder but their partner or spouse would also need to be in employment to qualify for settlement. This could affect hundreds of thousands of partners and spouses who have taken on primary childcare responsibilities or reduced their working hours specifically to support their family, while the main visa holder builds their career and meets settlement requirements. The proposals also include a 20-year settlement route for workers who have claimed public benefits for more than 12 months and a 30-year route for anyone with any history of overstaying or irregular immigration status. There is one confirmed detail within this category of proposals that you should hold on to. The government has officially confirmed that none of these proposed changes will affect people who have already obtained settlement, meaning if you already hold indefinite leave to remain, you are not affected by any of this, regardless of what the final decision says. The critical unanswered question, the one that has dominated every parliamentary debate, every legal submission, and every petition on this topic, is whether the final decision will include transitional protections for people who are already living in the UK on current settlement pathways. The Home Secretary has publicly suggested she believes exempting people already here is unreasonable, but the level of political pressure from within her own party, from trade unions, from civil society organizations, and from affected communities may yet influence what gets published. The answer is coming before the end of March. That is weeks away, not months. Now let's look at the third and final category. These are confirmed future changes, not proposals, not consultations. Already confirmed in legislation or official government announcements with specific implementation dates, they are coming regardless of any consultation outcome. From the 1st of January 2027, the graduate visa will be reduced from 24 months to 18 months for undergraduate and master's graduates. PhD graduates will retain their 36-month graduate visa, but everyone else needs to plan around 18 months, not 24. If you're currently studying in the UK and thinking about your post-study strategy, this changes your transition timeline from graduate visa to skilled worker sponsorship considerably. Build your plan around 18 months now and don't get caught adjusting it last minute. Also confirmed for the 31st of December 2026 is the expiry of the temporary shortage list, which currently allows certain occupations to recruit internationally even if they don't meet the standard skilled worker criteria. What happens after that date, whether the list gets renewed, replaced with something different, or simply ended, has not been announced. That uncertainty is already affecting workforce planning decisions in several sectors. And finally, from August 2028, universities will be charged $925 per international student per year through a new immigration levy intended to fund enforcement and compliance. Universities are already factoring this into their long-term financial planning. And some institutions are beginning to review how many international students they can sustainably support under this new cost structure. Here is the complete picture in plain terms. The care worker recruitment ban, the removal of RQF 3 to 5 roles, the 32% skills charge increase, the B2 English requirement, and ETA enforcement are all already in force right now. The 10-year ILR proposal, the 15-year care worker route, dependent work requirements, and the retrospective application question are all still being decided, with an announcement due by the end of March. The graduate visa reduction, the temporary shortage list expiry, and the university student levy are all confirmed for future dates. That is the real, complete, accurate state of UK immigration as of today. This is exactly why GoUKGo exists. Because the confusion between what's confirmed and what's proposed is causing genuine harm to real people making real decisions about their real lives. If this breakdown finally gave you the clarity you've been looking for, hit that like button right now, because this information needs to reach every international worker, every care professional, every student, and every dual national in the UK who is navigating this system right now. Subscribe and turn on notifications immediately, because the moment the government publishes its formal response to the ILR consultation, I will be here breaking down exactly what was decided, what it means for every visa category, and what options are available to everyone affected. Drop a comment below and tell me which category hits closest to home for you. Are you dealing with one of the already confirmed changes, anxiously waiting on the ILR proposals, or planning around the confirmed future changes? Share this video with every international worker in your network. Because right now, accurate information isn't just helpful, it's everything. End of March is weeks away. Until that announcement drops, operate under the confirmed rules, prepare for multiple possible outcomes on the proposals, and stay right here on GoUKGo so you never get left behind again.